Hello and welcome. My name is Alan, and today we'll be looking at the last part of the Taney Court, the cases of the Taney Court. So let's go ahead and jump into this. These are not near as many as the Marshall Court, though the length that Taney was Chief Justice, there still is a fair number of them. Let's go over the few that we just want to kind of mention here. We have United States versus Segui, and it was a case about upholding the validity of a Spanish land grant in Florida. So you have to remember, I think it was around this time that Florida was being ceded to the U.S. Okay, so the U.S. gains Florida in 1819, according to history.state.gov, as part of the Treaty of Adams-Onis. So Florida became a U.S. territory. Treaty of Adams-Onis, also known as the Transcontinental Treaty, the Florida Purchase Treaty, or the Florida Treaty, was between the United States and Spain in 1819 and ceded Florida to the United States and defined the boundary between the U.S. and New Spain. Because you have to remember, the Louisiana Purchase itself had been argued for a long time, but Spain claimed it owned the Louisiana territory. France claimed they owned it, and the U.S. ended up taking the opportunity and bought it from France, which gave Napoleon Bonaparte money he needed for his European wars. So you have Spain feeling like it owns the rest of it, Florida and much of Mexico. And it was in 1821 that Mexico itself gained its independence from Spain in the Treaty of Cordoba. During the time of this, Spain probably felt, well, it will make it a bit difficult to take care of Florida if you own everything else that surrounds it. So we'll just cede you Florida if you leave these lands to us. And so that was agreed upon in the Adams-Onis Treaty. And that's why this comes up in the United States versus Segui, upholding the validity of a Spanish land grant in Florida, because the case takes place in 1836. And it is essentially a citizen claiming he has a land grant, a right to that land that was provided to him by Spain, where they granted him the land in Florida. Another case we'll mention is Swift versus Tyson. It dealt with federal common law in diversity jurisdiction cases and would later be overturned. Let's see, it was a case that, according to Wikipedia, it was a case that brought in diversity in the Circuit Court for the Southern District of New York in a bill of exchange, except in New York, in which the Supreme Court of the United States determined the United States federal courts that heard cases brought under their divisions. Another case we just want to kind of mention is Luther versus Borden, which dealt with the guarantee clause of Article 4 of the United States Constitution. And according to Wikipedia, the case is one in which the Supreme Court of the U.S. established the political question doctrine in controversies arising under the guarantee clause of Article 4 of the United States Constitution. The guarantee clause mandates that the United States guarantee that all states have a republican form of government, though it does not define this term. Article 4 itself outlines the relationship between the various states, as well as the relationship between each state and the U.S. federal government. It also empowers Congress to admit new states and administer the territories and other federal lands. So, Luther versus Borden. Next case we want to kind of just mention is the passenger cases. Smith versus Turner and Norris versus Boston, which dealt with taxation of immigrants and the constitutionality of state laws regarding foreign commerce. And it says they were two similar cases argued together before the U.S. Supreme Court, which decided 5-4 that states do not have the right to impose a tax that is determined by the number of passengers of a designated category on board a ship. And it kind of fades out where it's just a little preview by Wikipedia. But yeah, passenger cases. Next case we just kind of want to mention is Sheldon versus Sill, which dealt with congressional control of the jurisdiction of the lower federal courts. And as per Wikipedia, the little preview says it was a ruling by the U.S. Supreme Court holding that Congress may restrict the jurisdiction of the lower federal courts by limiting the subjects those courts may hear, even if those subjects fall within the federal judicial power defined by the U.S. Constitution. Next case we just kind of want to mention is Hotchkiss versus Greenwood, which says in the summary is an early standard for non-obviousness in the United States patent law. And a little preview from Wikipedia shows that it was a decision credited with introducing into U.S. patent law the concept of non-obviousness as a patentability requirement, as well as stating the applicable legal standard for determining its presence or absence. Next case we just want to kind of mention is Strader versus Graham. And summary says it dealt with slavery and the application of state laws thereof. A little Wikipedia says it was a U.S. Supreme Court decision that held that the status of 3 slaves who went from Kentucky to Indiana and Ohio depended on Kentucky law rather than Ohio law. Even though they were in Indiana and Ohio, where they were considered property, they were still dependent upon the law that was made in Kentucky. So that was a law they still had to follow, according to the Supreme Court decision. Next case we just want to kind of mention is Abelman versus Booth, which dealt with the contradiction of federal law by the states. And the little preview by Wikipedia says that it was a Supreme Court case in which the court unanimously held that the state courts cannot issue rulings that contradict the decisions of federal courts, overturning a decision by the Supreme Court of Wisconsin, essentially saying state laws do not supersede federal law. Other cases we want to take a little deeper in-depth look at is the Charles River Bridge versus Warren Bridge, which states it was about the contract clause of the Constitution. The contract clause, according to Wikipedia, states it is Article 1, Section 10, Clause 1 of the U.S. Constitution, also known as the Contract Clause, and it imposes certain prohibitions on the states. These prohibitions are meant to protect individuals from intrusion by state governments and to keep the states from intruding on the enumerated powers of the U.S. federal government. So let's take a look at that. Constitution, Article 1, Section 10, Clause 1. It says, no state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. So essentially, it's setting out that there are certain things these states cannot do, and it must be done by the federal government because we want to protect these individuals from the state governments. Because you have to remember, a lot of what the Constitution is written for is to fix issues caused by the Articles of Confederation. It says it also keeps states from intruding on the enumerated powers of the federal government, which, according to Wikipedia, the enumerated powers of the United States Congress are those powers granted to the federal government of the United States. Most of these powers are listed in Article 1, Section 8 of the U.S. Constitution. But yeah, Charles River Bridge versus Warren Bridge deals with that contract clause of the Constitution. And it was a case, according to Wikipedia, was a case regarding the Charles River Bridge and the Warren Bridge of Massachusetts, heard by the U.S. Supreme Court under the leadership of Chief Justice Roger Taney. In 1785, the Charles River Bridge Company was granted a charter to construct a bridge over the Charles River connecting Boston and Charlestown, roughly where the present-day Charlestown Bridge is located. And when the Commonwealth of Massachusetts sanctioned another company to build the Warren Bridge in 1828, that would be very close in proximity to the first bridge and would connect the same two cities. The proprietors of the Charles River Bridge claimed that the Massachusetts legislature had broken its contract with the Charles River Bridge Company, and thus the contract clause had been violated. The owners of the first bridge claimed that the charter had implied exclusive rights to the Charles River Bridge Company. The court ultimately sided the Warren Bridge. This decision was received with mixed opinions and had some impact on the remainder of Taney's tenure as Chief Justice. And essentially, the holding was that the Massachusetts state legislature's decision to grant a charter to the proprietors of Warren Bridge after granting a similar charter to the Charles River Bridge Company did not constitute a violation of the contract clause. Another case we want to mention is the Amistad case, United States versus Schooner Amistad, which dealt with slave trade and slave ownership. If you'll remember, there is a movie called Amistad, which I believe has to do with this very case. And as per Wikipedia, it was a case resulting from the rebellion of Africans on board the Spanish schooner La Amistad in 1839. It was an unusual freedom suit that involved international issues and parties, as well as United States law. Historian Samuel L. Morrison described it in 1969 as the most important court case involving slavery before being eclipsed by that of the Dred Scott case in 1857. And this case was in 1841, so yeah. Essentially, according to Wikipedia, the schooner was traveling along the coast of Cuba on its way to a port of resale of the slaves. The African captives, Mende people, who had been kidnapped in the area of Sierra Leone in West Africa, illegally sold into slavery and shipped to Cuba, escaped their shackles and took over the ship. They killed the captain and the cook. 2 other crew members escaped in a lifeboat. The Mende directed the 2 Spanish navigator survivors to return them to Africa. The crew tricked them, sailing north at night, and Le Amistad was later apprehended near Long Island, New York, by the United States Revenue Cutter Service, the predecessor to the U.S. Coast Guard, and taken into custody. The widely publicized court cases in the U.S. Federal District Court and eventually the Supreme Court, which addressed international issues, helped the abolitionist anti-slavery movement. The holding for the case says the Africans are free and are remanded to be released. Lieutenant Gedney's claims of salvage are granted. Remanded to the U.S. Circuit Court for the District of Connecticut for further proceedings in monetary matters. The next case we want to kind of mention a little more in depth is Cooley versus the Board of Wardens, which it says deals with pilotage laws under the Commerce Clause. And the Commerce Clause describes an enumerated power listed in the U.S. Constitution, Article 1, Section 8, Clause 3, which is to regulate commerce and with foreign nations and among several states, and with the native tribes, the Indian tribes, it says so. Cooley versus the Board of Wardens is 1852, and the short synopsis by Wikipedia states it was a U.S. Supreme Court case in which the court heard that a Pennsylvania law requiring all ships entering or leaving Philadelphia to hire a local pilot did not violate the Commerce Clause of the Constitution. The last one before we get to 2 that we want to go really in depth of is the prize cases, which was from 1863 and dealt with presidential powers in wartime. And the little synopsis under per Wikipedia reads. It was a case argued before the Supreme Court in 1862 during the American Civil War, and the Supreme Court's decision declared the blockade of the southern ports ordered by Abraham Lincoln constitutional. Yeah, one thing you have to kind of remember is that Lincoln did have these southern ports blockaded. Charleston, Savannah, a number of the big southern ports, because Europe was very interested in how this would go and was willing to join the South Side if they thought they could get a cheaper deal. As per Holding in Wikipedia, it says the president did have the authority to order a blockade and impound ships, even without a formal declaration of war. But now we want to look at the two big cases. The first is 1842's Prigg versus Pennsylvania, and it deals with runaway slaves. The facts of the case, as per oyez.org, the Pennsylvania legislature passed laws in 1788 and 1826 prohibiting the removal of Negroes out of the state for the purpose of enslaving them. In 1832, a black woman named Margaret Morgan moved from Maryland to Pennsylvania. Although she was never formally emancipated, her owner, John Ashmore, granted her virtually full freedom. Ashmore's heirs wanted her returned as a slave and sent Edward Prigg to capture her in Pennsylvania. After returning Morgan to Maryland, Prigg was convicted in a Pennsylvania court for violating the 1826 law. Prigg unsuccessfully argued before the Pennsylvania Supreme Court that both the 1788 and 1826 laws violated the constitutional guarantee of extradition among states, and that the federal government's fugitive slave law of 1793. So the question before the Supreme Court of the United States was, did Pennsylvania's law prohibiting the extradition of Negroes to other states for the purpose of slavery violate Article 4, Section 2 of the Constitution? Did the law violate the fugitive slave law of 1793 as applied by the Supremacy Clause? So let's take a look at those clauses. The first one it asked about is Article 4, Section 2. Okay, as per Article 4, Section 2 of the U.S. Constitution, it says, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. A person charged in any state with treason, felony, or other crime, who shall flee from justice and be found in another state, shall, on demand of the executive authority of the state from which they fled, be delivered up to be removed to the state having jurisdiction of the crime. No person held to service of labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be charged from such service into labor, but shall be delivered upon the claim of the party to whom such service or labor may be due. And the other one is, did the law violate the Fugitive Slave Law of 1793 as applied by the Supremacy Clause? Let's take a look at that Supremacy Clause. Per Wikipedia, Supremacy Clause says the Constitution, the Supremacy Clause of the Constitution establishes that the Constitution, federal laws made pursuant to it, and treaties made under its authority constitute the supreme law of the land, and thus take priority over any conflicting state laws. And it provides that state courts are bound by and state constitutions subordinate to the supreme law. Conclusion, according to oyez.org. Yes and yes. So they claimed that it violated both laws. Justice Joseph Story delivered the opinion of the court. The 1788 and 1826 Pennsylvania laws contradicted Article 4, Section 2 of the Constitution and the Fugitive Slave Law. The Supremacy Clause assured that federal laws prevailed over the state laws, and the decision did not wholly end asylum across state lines for slaves. Story granted that the state laws put in place by slave states to recapture slaves in free states only had to be enforced by federal officials and not state magistrates. They said, yes, it did violate both laws, but they did add, it has to be federal officials who capture those slaves, and not members, authorities of a state who do the capturing. And that's probably where they was like, we feel that it shouldn't have been prigged, but otherwise the laws were violations of these laws and ideas. So, and then the other one we want to mention, that we want to talk about, and this is the most important one that we've already mentioned before about the Taney Court. 1857, Dred Scott versus Sanford. It dealt with slavery and the definition of citizenship. As per Wikipedia, it says, often referred to as the Dred Scott decision. Dred Scott versus Sanford was a landmark decision of the U.S. Supreme Court, in which the court held that the U.S. Constitution was not meant to include American citizenship for black people, regardless of whether they were enslaved or free. And so the rights and privileges that the Constitution confers upon American citizens could not apply to them. So let's take a closer look at it in oyez.org. The facts of the case were Dred Scott was a slave in Missouri from 1833 to 1843. He resided in Illinois, a free state, and in the Louisiana Territory, where slavery was forbidden by the Missouri Compromise of 1820. After returning to Missouri, Scott filed suit in Missouri court for his freedom, claiming that his residence in free territory made him a free man. After losing, Scott brought a new suit in federal court. Scott's master maintained that no Negro or descendant of slaves could be a citizen in the sense of Article 3 of the Constitution. Article 3, it has two sections. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their office during good behavior, and shall, at stated times, receive for their services a compensation which shall not be diminished during their continuance in office. And the judicial power shall extend to all cases in law and equity arising under the Constitution and laws of the United States, and treaties made or which shall be made under the authority to all cases affecting ambassadors, other public ministers, and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to commonwealth between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants by different states, and between a state and the citizen or the citizens thereof, and foreign states, citizens or subjects. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions, and under such regulations as the Congress shall make. The trial of all crimes, except the cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed. When not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. Treason against the United States shall consist only in levying war against them, or in adhering to their enemies giving them aid and comfort, no person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. The Congress shall have power to declare the punishment of treason, and no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. And that's what it says in Article 3 of the Constitution. Now, the question before the court and dealing with the case was Dred Scott free or slave? And the conclusion, in a 7-2 decision for Sanford, the majority opinion given by Roger B. Taney held portions of the Missouri Compromise unconstitutional in violation of the Fifth Amendment, treating Scott as property, not as person. And of course, if you remember when we were going over the justices, it was the case that Curtis said he dissented upon and thus resigned from the court in regards to. So the majority held that a Negro whose ancestors were imported into the U.S. and sold as slaves, whether enslaved or free, could not be an American citizen, and therefore did not have standing to sue in federal court. Because the court lacked jurisdiction, Taney dismissed the case on procedural grounds. Taney further held that the Missouri Compromise of 1820 was unconstitutional and foreclosed Congress from freeing slaves within federal territories. The opinion showed deference to the Missouri courts, which held that moving to a free state did not render Dred Scott emancipated. Finally, Taney ruled that slaves were property under the Fifth Amendment, and that any law that would deprive a slave owner of that property was unconstitutional. In dissent, Benjamin Robbins Curtis criticized Taney for addressing the claim's substance after finding the court lacked jurisdiction. He pointed out that invalidating the Missouri Compromise was not necessary to resolve the case, and cast doubt on Taney's position that the founders categorically opposed anti-slavery laws. John McLean echoed Curtis, finding the majority improperly reviewed the claim's substance when its holding should have been limited to procedure. He also argued that men of African descent could be citizens because they already had the right to vote in 5 states. And that is Dred Scott versus Sanford, one of the more important cases in history that really kept the fires burning for the Civil War that was looming just ahead. The Taney Court ends in 1864. And when we get a new Supreme Court justice at the end of 1864. In Psalm P. Chase. And when we next go into another Supreme Court video, that's the Chief Justice we will be going over, as well as his court and the cases. But I'll see you all in the next video. As always, educate thyself. Think, read, study, learn. Someone tries to tell you something you have trouble believing, ask them to cite their sources. Speaking of which, I'll be listing these sources in the description below the video. I'll see you all in the next one. Until then, later.